So can your wife file a default judgment against you in a divorce? Can you be divorced by default? Well, I mean, the short answer is you can. You know, a divorce suit is like any other lawsuit. It starts out that way. You file a complaint for divorce through the circuit county, the county where you live, get a complaint filed, you can maybe get some court orders signed. That's easily done at the beginning of a divorce, and then you serve the other person with the papers. So just like any other lawsuit, you serve them with papers, give them their time to respond, and then you could file a default. And then at that point, you could go forward without that person's input or even really their further knowledge of what's going on or anything. And then at the end of that, they're divorced, and the divorce judgment is basically something that really they've had no say in and have no contribution to, and they are then stuck with. So, you know, let's talk about that a little further here. First of all, I'm attorney Brent Boyer. I'm with Adam. We represent men who do divorce, family law, you know, that type of work. So don't forget to like the video, subscribe to the channel. We'd appreciate it. So yeah, as far as defaults, you know, your wife can file this lawsuit, this divorce case. She starts it. A divorce is not something that's done together. Either she files it, she's the plaintiff, and she gets all the advantages of filing first, or you file first and you're the plaintiff. If she files first, your wife files first, she gets the complaint filed with the circuit court, gets a summons issued, possible to get some court orders signed, what are called ex parte orders. So in other words, these court orders without a hearing. And now they got this pile of paperwork. They're going to then serve you with those papers. Once you're served with court papers, you then have 21 or 28 days to respond. 21 days if it's by personal service, or if you sign for it, sign like an acknowledgement of service that you received it, or 28 days if it's by mail, registered mail, which really doesn't get done a lot anymore, certified mail. So it's possible. So it's 21 or 28 days to respond, so consider it 21. But then within that time frame, there's also these court orders that you can get served with that are called ex parte orders. Those you only have 14 days to file objections. So there are definitely some timelines going on here, some pretty short window of when you're allowed to respond and when you have to respond in a divorce case. And you know, a divorce is like any other lawsuit. There are these court rules, there are state laws about how they proceed and what's required and what kind of a step-by-step process. If you don't have a lawyer, you're required to know what a lawyer knows about it, and you're required to follow the rules and go forward that way. So, you know, just like any other lawsuit, you know, for example, like let's say you had a lawsuit, somebody owed you some money, you did some work for someone, they didn't pay you, they owe you some money, and you file a suit to collect that debt through district court. Well, same kind of rules apply. If that person just decides to ignore it, they say, I don't care, I don't know that guy the money. You would have a right, once you file your complaint, you get them served with papers, and you can prove that they were personally served, they have knowledge of this lawsuit. You can then get a default judgment against them if they fail to respond within the allotted time, the 21 or 28 days. Now you get a judgment against them. Now you have a default judgment that says that they owe you the money, and that's done, usually with interest or penalties, whatever it is. So divorce is the same way. You file it, get the person served, you follow the court rules about time and service and process and all that type of stuff. And then if the other person, if the defendant does not respond, so in this case, if your wife has filed and you have not responded to it, you think, oh, I'm just going to ignore this, or I think we're trying to work it out. You could end up in default. You know, we had a client, I met with a client last week who had been served. His wife had gone forward with the divorce, but they were actually still living together. For months and months and months, they were living together. Obviously, she was telling him one thing, having an attorney do another. He had been defaulted. A default was entered and completed against him. His time to respond had long since come and gone, and now there was a divorce, and he gets this final divorce judgment that he has no say in. And of course, it's not fair. I mean, they always are looking to try to do something to get an advantage. So now there's a divorce judgment that's been completed. The divorce is final. He's not gotten his fair share of things. The retirement accounts were all screwy. He didn't get his share of the retirement like he was supposed to. There were issues with what was going on with the house, and the wife putting too low of a value on the house for the buyout, all kinds of problems. You know, one place where you do have some protection, even in a default situation, is with custody, parenting time type of stuff. So there are laws that say that a judge is required to make independent findings on custody. So really defaulting you on custody is harder to do. It can still be done the right way. But in general, you can't ignore it. You can't assume they're not going to go forward with you. You have to assume a default could be entered against you if you don't respond in time. And if your wife says, oh, don't worry, I'll put it off, I'll hold off on the default, I'm not going to do that right away, you can't really count on that. You got to assume that there are these deadlines and these go forward. And the idea with a divorce case and with any lawsuit is once a complaint is filed, once the other person is served, and they have their allotted time to respond, if they do not respond, there's only two ways to go. Either that person files an answer, which is a written response to the complaint. You file that with the court, send a copy to her attorney if she has one. So you file the answer. If you don't do the answer, if you don't file an answer and you ignore it, they have to do a default. So it's not necessarily like filing a default against you is being done to cause you harm or to be mean about it. There's only two paths. Either they go forward, they follow all the rules, and you ignore it and they file a default against you, and then they proceed with a divorce. Or they go through this process, they get you served, and you file a response, you file an answer. If neither of those two things happened, if there's no default and there's no answer filed, now they can't get divorced. The case will get dismissed for lack of what they call lack of progress. So you do have to be aware that these timelines are coming and going, and you have to respond. And it's really not up to your wife and her attorney to tell you, "Oh, don't worry about it. We'll put it off." Because really, they won't. They won't be able to. At some point, they'll be at a place where they either have to default you and do whatever they want, proceed without you, or they need you to file an answer. So, you want to keep all that in mind as you're looking at things and how this all goes. And, don't forget to look us up. We're also on Instagram, we're on Facebook, we're on Twitter, we're on TikTok, we're everywhere. We're divorce attorneys, family law. That's all we do. I hope that helps. Thanks.